Hey everybody, Todd Vandermine back for another edition of Freedom Steel. I know it's been a minute since we've been on here. We'll get to that right after the intro. But hey, yesterday the Seventh Circuit Court of Appeals issued their decision in the Schoenthal case, which is about public carry on mass transit. And it is a bad decision. It is not just a bad decision, it's a dangerous decision. And I think it sets about a whole new level of craziness with the appellate courts. This is not just, rewriting Bruin, Heller, or whatever. This is just flipping the double middle finger to the Supreme Court and trying to find workarounds around what they said in Bruin. So let's get into it right after the intro. Hey everybody, Todd Vandermine, former NRA contract lobbyist, Illinois gun law guru, the tactical Santa or gun Santa on some social media platforms. So hey, yesterday the Seventh Circuit Court of Appeals in a three-judge panel, which consisted of Ripple and St. Eve, and I'm drawing a blank, and a Kolar. That would be a Reagan appointee, a Trump appointee, and a Biden appointee, ruled on the mass transit and reversed the lower court, stating that the ban on mass transit fits with history and tradition. Although we've got some simple points here. Now, I know I've been gone for a while from producing videos. The wife and I took a couple of trips in the RV. I've been out at the club building all kinds of crazy stuff. Just been real busy this summer and things slowed down. But now we've got things happening, and I think this decision has a lot of implications. So let's run through this stuff real quick. First off, there's interest balancing throughout this decision, cloaked in history and tradition, much like Easterbrook claimed in the Friedman decision when they did the PI ruling on Beavis and the other cases. They said that Friedman was not interest balancing, but it was that it was history and tradition. Bullpucky. This is just another one of the Seventh Circuit continuing on trying to cloak their interest balancing in in just trying to justify it via text and history. Two, they're trying to expand the relevant time frames for laws and analogies well past the founding, past the ratification of the 14th Amendment, and are now pushing all the way up into 1960, which would naturally include the National Firearms Act. They are making this move. They're going to force the Supreme Court to set down a timeline. Judge St. Eve is on this panel. She is now 4 for 4 with the anti-gunners on panels and decisions she's been on at the appellate court. I think this votes very badly in terms of the Barnett case and that stuff. I think that St. Eve is going to rule against us. I think it is no longer an if, but if the panel that has been handling the motions, Brennan, St. Eve, and Easterbrook, continue and are the panel that we expect, then we're going to lose. And I think they're going to, I can only hope they write a decision that's as bad as the one that we got yesterday, because that will just be even more epic smackdown by the Supreme Court if they take the Barnett case. And lastly, what this video is going to focus on is they've set a new standard. They are now equating crowded and confined spaces with sensitive places and setting up a new test. And this becomes the very dangerous part of this ruling, because no place is off limits that they can ban. I mean, you're going to be left with a sidewalk law that you can traverse the sidewalk And that's about it, the way this thing could be applied. So this is going to lead to about 2, 3, 4 videos to break it all down. My friend Bill Kirk just did a video on this earlier today. He beat me to it, and he gave me a shout out in it. Thank you very much, Bill. He does a very good encapsulated, kind of hitting all the highlights. Like I said, I'm going to focus this video on this new sensitive places that equates to confined places or crowded places. So they start off this decision with, yet the sensitive places doctrine tells us that the appropriate balance allows for temporary restrictions in scattered discrete places where the risk is simply different. More interest balancing. But that's the prelude to what we're this sensitive places, confined places, crowded places. So before concluding that Illinois may temporarily ban So, before concluding that Illinois may temporarily cabin an individual's right to carry a firearm while using a crowded transit system, we continue our analysis. The fix was in. From the beginning, they had an idea and they decided to turn around and comport their reasoning to a predetermined outcome. They go back to the statute of Northampton, which the Supreme Court has routinely rejected, and they just try to bootstrap that up all over again. And they said that another law built on the principle that they originated in the Statute of Northampton by flatly banning carrying firearms and confined in crowded spaces without any terror requirements. Remember, the statute from Northampton said you had to go armed to incite terror. And here we go. Several more laws show that just as crowded place laws existed long before Reconstruction, they persisted afterward. In 1879, New Orleans expanded its firearm prohibition to cover, quote, any theater, public hall, tavern, picnic ground, place for shows or exhibitions, house or other place of public entertainment or amusement. That doesn't leave a lot left over. Hence why I think that this is all about restricting us to sidewalks. If they don't like carry, they're going to narrow and make it almost impossible. That's what this kind of threshold does. And they go to the, when they're citing the Second and the Ninth Circuit, it's bad. On a similar record, the Second Circuit concluded the nation not only tolerated the regulation of firearms in crowded spaces, but also found it aberrational that a state would be unable to regulate firearms in such spaces. And citing Antioch, said differently, a high population density in discrete, confined spaces has historically justified firearms restrictions, much like the Times Square ban, which we're going to have to get Antioch and these revised May issue laws with their limiting structures up to the court, and they're going to have to take it up. Maybe this is a case. I don't know. They go on, we agree with our sister circuits that hold that regulations in crowded and confined places are ensconced in our nation's history and tradition. As we see it, crowded spaces restrictions fall under the sensitive places doctrine. To clarify our terminology, any location where firearms can be banned is accurately described as a sensitive place for the sake of Second Amendment inquiry. So that means any place they can get away with a ban is now a sensitive place, which means they get to use that as another analogous location to bootstrap up all the other stuff that they want. They also then added this other issue. The government's second way of analogy is that children regularly take public transit. So now they are bringing in that just because the kids are there, where we heard this before, Cook County has been making this argument and trying to recodify their prohibition on forest preserves. And with the underlying law cited before about parks, I don't know how that's going to work. I would say that if the Cook County suit was brought tomorrow after this was done, that we would not have gotten the result that we got at the circuit court, finding that Cook County's ban was unconstitutional. Now we've got this. Cook County chose not to appeal that. Um, this is not good. This is where it's dangerous. Citing that because you have kids, you can turn around and use that as one of the justifications. Because what they do is um, they they compare kids being present to the reason you don't get to have a gun in a school. They analogize them to be one in the same. So if you can make this overt showing about kids and a crowded space, then there you go. You can ban guns. So, and they specifically cite daycare areas in our earlier part of the decision. Going on, they sit there and say, here's their new test. 1, temporary regulates the manner of carrying firearms. 2, in a crowded and confined space. 3, where that space is defined by a natural tendency to congregate people in greater density than the immediate adjacent areas. 4, the space furthers important social interests, interest balancing all over again. 5, the presence of firearms in that space creates a heightened risk to maintaining public safety. And yet earlier they said that there are places that firearms just don't belong. They think that firearms are dangerous. This is a horrific ruling, one that seeks to literally just gut the life out of Bruin and your right to carry a firearm for self-defense in public. I don't know if there's going to be a cert petition on this. There should be. Whether or not the court's going to take it is something else. But here you have a merits case. You have a final judgment. It might leapfrog into Antonuck. I think that if there is a plea to take this up to the court, I think all the major gun groups should jump on in amici briefs and go down the road on this. Look, this is bad. And this whole new doctrine of crowded places, confined spaces, one and the same, that now equate to sensitive places, or sensitive places can be anything the government decides they can ban guns from, and they're literally, in some ways, they're shifting the burden. Kids in parks, we're never going to, under this decision, we'll never overturn a parks ban. The Cook County Forest Preserve and all the other forest preserves may come back. That we may lose ground on that. I just see this as a horrendous overreach. And we got Rahimi'd. As Bill points out, we got Rahimi'd because they keep making these broader and broader analogies. I mean, this isn't horseshoes or hand grenades close. This is like nuclear bomb close. This is like you don't even have to be in the same state close. That's how bad this decision is. And, you now have 3 appellate courts, and a couple of these, like Antonuck, was on a preliminary injunction. But they're treating that as just wholesale, as if it was a merits decision, and they got it all right the first go around, which, again, does not portend well for us in the Barnett case coming up in a couple of weeks. I think that, we're going to lose that. We're going to lose St. Eve again. They're going to find some BS description about, whether or not ARs or semi-auto guns are arms, yada, yada, yada. Yeah, I think we're going to lose. And St. Eve, even the Trump appointee, is going to be a problem until she gets smacked by the Supreme Court and told you're wrong. And I think that's what we really need. The Supreme Court has to quit dancing around things and being obtuse and being just kind of, well, we'll get to that later. No, this is what happens when they don't draw bright lines. So, as far as Barnett, if we're going to lose, let's hope we lose fast so we can get in front of the court this term with a cert petition. But hey, that is it in a nutshell. I'm trying to keep these videos to under 15 minutes. So, as always, thank you very much. Like, subscribe, copy, share, pass this thing around to your social media and your friends. Not good news, and like I said, I think this is a very, very dangerous decision. So, with all that, we'll be back with a few more videos on breaking down some more of the detail in this. But as always, frag out.